Good morning, everyone. It's Coffee and Politics 101 with Cydney Walker, and today we are finally getting to do the mock voir dire session that we were supposed to do in January. So thank you to my guests for rescheduling. Thank you to my mock jurors for coming on. We have the mock proceedings being presided over by Judge Rhonda Hunter, who is the judge of the 303 District Court in Dallas County. That is the family court. This is something that we typically don't see in family court cases. My first time hearing about a jury trial was, I think, about 2 or 3 years ago. And it just happened to be a really high profile case. So I am going to turn it over to Judge Hunter. We have attorneys Sandre Moncriffe and Stacy Dunlop, who will go through the questions for us, the mock jurors. So Judge Hunter, good morning. Thank you.
Good morning. Thank you so much. And we're going to proceed as though we're in the courtroom. So hello, members of the prospective jury panel.
Good morning.
Good morning. Thank you all for being here and for carrying out your civic duty. The court appreciates that. I'm Judge Rhonda Hunter, and you are in the Family District Court of Dallas County. We handle a number of different types of cases in Family District Court, including divorce and child custody, property division, adoption, paternity, and child welfare. Today, you will be sitting on a case that is a termination of parental rights case. That means that one of the parties in this circumstance, the state of Texas, has requested that a parent who under law has rights and duties regarding their children is asking that that parent no longer have their parental rights. This is the most serious of family law cases. And because it is the most serious of family law cases, special rules do apply to this case. As the judge, I will make rulings on whether certain evidence is admitted, but you will be the judges of the facts. So it is very important that you listen to all of the evidence because you will ultimately be making decisions. This trial will take place in 3 phases. This first phase is called the jury selection phase, or voir dire, or voir dire. And in this phase, the lawyers will have an opportunity to ask you questions. And you have the opportunity to answer those questions. The next phase will be the evidence phase. And the final phase will be the jury deliberation and the verdict phase. The lawyers in this case are Ms. Sandre Moncriffe and Mr. Stacy Dunlop. First, I will give you instructions, and then I will administer the oath. Your instructions are: avoid looking like you're friendly with one side or the other in the case. Do not mingle or talk with the lawyers, witnesses, parties, or anyone else involved in the case. Do not accept any favors from any lawyers in this case. Do not discuss this case with anyone, even your spouse or a friend, either in person or by any other means, phone, text message, email, chat room, blog, or social networking until this case is completely over. The parties through their attorneys have the right to ask you questions about your background, your experiences, and your attitudes. They're not trying to meddle in your affairs. They're just being thorough and trying to choose fair jurors who do not have bias about this particular case. Remember, you are taking an oath and you will tell the truth. So be truthful when the lawyers ask you questions and always give complete answers. Now, at this time, jurors, prospective jurors, please raise your right hand. Do you solemnly swear or affirm to tell the truth in answering the questions to be propounded to you during this examination?
I do.
I do.
Thank you. You may lower your hand. Ms. Moncrieffe.
Okay. Good morning, ladies and gentlemen of the jury.
Thank you so much for being here with us this morning. I will briefly introduce myself. I am Sandre Moncriffe, an assistant district attorney in Dallas County, where I work under our esteemed district attorney, John Crusoe. Again, the district attorney's office thanks you very much for your service in coming out and being a juror this morning. We know that the jury summons never quite comes at the right time, but we do respect and appreciate your willingness to be here with us this morning. As Judge Hunter told you briefly, this is a case regarding the termination of parental rights. Termination of parental rights, what does that mean? Termination of parental rights means that a parent's rights based on decisions made here today could be forever severed. It is as if that child was never born to that parent based on an order of termination. So it is a very, very serious matter that we're here regarding today, a termination of rights. In order to get there, we, the prosecution, who I represent the Assistant District Attorney's Office, as well as my client in this case is Texas Department of Family and Protective Services, otherwise known as CPS, and we will be asking for termination of rights as to the parents seated before you today, John Brown and Mary Sue Jones. Again, we do not take this lightly, and we ask that you pay particular attention to the evidence that will be put on before you. And we are now in the voir dire phase of our termination proceedings, and this is what I refer to as speed dating. It is merely an opportunity for us to get to know you, why you think the way you think, and to maybe also clear up some questions that you may have regarding the proceedings you're going to hear. The proceedings you're going to hear today, a termination case, I know for most of you, you hear from possibly the criminal standpoint of reasonable doubt. That is not the standard that we're using today. The standard we're using today is the clear and convincing evidence standard. And it is simply as it sounds. Is the evidence clear? And are you convinced? That is the standard, and that is the burden that I, the prosecutor, as well as my client CPS are shouldering here today. That is the burden that we have to overcome, clear and convincing evidence.
Wow.
So without further ado, I'd like to ask you a couple of questions. Okay, I'd like to ask you a couple of questions. Is there anybody here who in no way, shape or form that could never ever agree to terminate somebody's parental rights?
Nope.
No.
No? All right. Or a case involves the usage of drugs, some drug usage involved in your case. Is there anybody here who's had family members or yourself personally with a history of addiction or drug usage? Ms. Walker?
No.
I had a cousin during the crack era that was very involved, lost his house, job, all that good stuff.
Okay. Does anything about that make you feel that you could not fairly evaluate the evidence offered here before you today?
No, I mean, I understood why he lost his job. So, I mean, it made sense that, you know, he would hit the bottom of the barrel before getting himself together.
All right. And is there anybody here who absolutely, well, let me move that up a notch. This case may also involve some domestic violence. Is there anybody here who's been affected by domestic violence or knows someone who's been affected by domestic violence?
I've been involved with helping women's shelters with students over the summertime. We take students of domestic violence whose mother has been sheltered. I've been involved with that over many years, but that's the limit of my experience. Nothing on the personal side.
And does anything about that prevent you from hearing the evidence in this case and making decisions?
Not at all.
Okay. Now, as part of our proceedings, the state, who I represent, will be bringing forth some experts that will be here to interpret for you psychological results and things of that nature. Are you willing to listen, or is there anything about your experience that makes you unwilling or unable to listen to expert testimony and give it the weight that it deserves?
No.
No.
Okay. All right. Now, as part of what we do is to try to get you all to talk a little bit more, about yourself, so that we can just make sure you don't have any preconceived notions about our case. It is very important that we get jurors who will just operate with impartiality, fairly, and treat the evidence as they hear it and make the decisions based on the law, clear and convincing evidence. So without further ado, thank you very much. I thank you for your time and being here, and you will hear from me again shortly. Thank you.
Thank you for that introduction, Ms. Moncrieffe. Mr. Dunlop.